America's new immigration law. What every green card holder and visa holder must know. Imagine waking up one morning to discover that a single mistake you made years ago, something you already paid the price for, could now get you deported from the very country you built your entire life in. That is the new reality millions of immigrants may be facing today. Congress has officially passed one of the most comprehensive immigration reform packages in modern U.S. history. A reform many experts are calling the most dramatic shift in immigration law in decades. This new law, which received rare bipartisan support, reshapes how the federal government classifies, screens, and enforces immigration policy for every non-citizen across the country. This is not a small adjustment, not a minor update, and not a policy memo. This is a full legislative overhaul, and it affects nearly every category of non-citizen, from temporary visa holders to long-term green card residents. Supporters call it necessary. Critics call it dangerous. But regardless of where you stand, this law changes everything. Today, we break down the new rules, the new risks, and the new reality of immigration in America. A new immigration classification system. At the heart of this reform is a complete reclassification of all non-citizens. For the first time, temporary visa holders, permanent residents, and longtime green card holders are grouped under a single enforcement category. This means the legal distinctions that many immigrants relied on for decades, the protections that came with long-term residency or stable green card status, are no longer guaranteed shields. Under the new structure, even lawful permanent residents now face expanded vulnerability if they violate federal public safety standards. For many who considered their green card a final stage of security, this law disrupts that sense of permanence. Expanded deportation grounds. The DUI standard. Perhaps the most talked about provision concerns DUIs. Under the new federal rules, a single DUI, yes, even one treated as a misdemeanor at the state level, can trigger deportation proceedings. Lawmakers behind the bill argue that DUI incidents are a serious public safety threat, pointing to thousands of alcohol-related deaths each year. They believe that lawful residents must be held to higher accountability standards and that dangerous behavior should have immigration consequences. But here is where the new law goes even further. Deportation can now begin without a formal conviction. Under certain conditions, simply admitting to conduct that meets the legal definition of a DUI could be enough to start removal proceedings. Legal analysts warn that this marks one of the strictest interpretations of DUI enforcement in immigration history. The second pillar, expanded inadmissibility. The law also creates new grounds of inadmissibility, rules that determine who can enter or remain in the U.S. Anyone with a DUI conviction, or anyone who admits to conduct that qualifies as a DUI, can now be deemed inadmissible. This affects visa applicants abroad, those seeking entry at U.S. borders, individuals applying for renewal, applicants for adjustment of status, permanent residents seeking citizenship. Even people who never served jail time may face consequences. Under the new framework, DUI behavior is officially categorized as a serious moral and legal violation. Federal law now overrides state classifications. Immigration law has always been federal, but states historically played a role in determining how offenses were classified. Not anymore. Under the new system, the federal immigration definition supersedes state definitions. If a state treats a DUI as a minor misdemeanor, federal authorities can still classify it as a deportable crime. This creates a uniform national standard, but also eliminates the protections many residents relied on through more lenient state laws. The new definition of good moral character. Naturalization applicants will face a major additional hurdle. The law now states that any single DUI conviction automatically disqualifies an applicant from obtaining U.S. citizenship. While parts of this idea existed in certain immigration interpretations before, they were not applied universally. Now, this rule is federal law. This means someone who has lived in America for 10, 15, or 20 years, paying taxes, raising children, and contributing to society, may be permanently barred from ever becoming a U.S. citizen due to one incident. Retroactive enforcement. Old cases reopened. One of the most concerning provisions for attorneys is the law's retroactive authority. Immigration officials may now reopen older DUI cases, even ones that were previously resolved. Because of this, immigration lawyers across the country are advising green card holders to request legal reviews before filing for renewals. Avoid international travel until their records are reviewed. Seek professional consultation before applying for citizenship. Many families are postponing travel, paperwork, or applications until more guidance is released. Administrative modernization, the other side of the law. While the enforcement side of the bill has drawn the most attention, the law also includes modernization efforts aimed at improving the immigration process. Congress has approved new funding for digital case processing, faster review of high-demand employment visas, expanded online filing systems, upgraded USCIS technology infrastructure. These reforms aim to reduce backlogs and create a more efficient system. However, advocacy organizations argue that these improvements are overshadowed by the strict enforcement measures that now define the reform package. Global impact, slower visa issuance, and stricter screening. U.S. consulates and national visa centers worldwide are preparing for stricter background checks, enhanced verification standards, longer administrative processing. This means international students, workers, and family-based applicants may experience delays, especially if their applications require interviews or extensive documentation. Social and emotional consequences. Across immigrant communities, fear and uncertainty are rising. Community centers, legal organizations, and advocacy groups are reporting surges in legal consultations, increased caution about travel, growing concern over old infractions, families seeking clarity and protection. For many, the new law feels like the beginning of a new immigration era, one defined not by opportunity, but by risk. What comes next? The Department of Justice and the Department of Homeland Security are expected to release detailed policy memorandums that will explain exactly how these rules will be interpreted day to day. Attorneys say the next several months will determine how aggressively the new provisions are enforced. Will every DUI trigger removal? Will officials distinguish between serious and minor incidents? Will discretion still exist? The answers remain uncertain. This reform is undeniably sweeping. It raises standards, narrows margins for error, and redefines what it means to be a lawful resident in the United States. For millions, the advice is the same. Stay informed, stay compliant, and seek legal guidance before making any major immigration decisions under the new law. As America enters this new chapter of immigration enforcement, one thing remains clear: the stakes have never been higher. For immigrants who have long contributed to the nation's economy, culture, and communities, understanding these rules is not just